Hello, this is Jesse Berg and Julia Ryland from the Great Plant Moody Law Firm in Minneapolis, and we are going to be talking for the next hour or so about breach analysis under HIPAA. This presentation that we are doing is one component of a project Great Plant Moody is engaged in along with the Minnesota Department of Health related to the Foundations in Privacy Toolkit, which is a joint publication by Great Plant Moody and Minnesota Department of Health related to the HIPAA Privacy, Security, and Health Information Exchange in Minnesota grant. We recently published the toolkit, and you can find a copy of it at the link on the slide that you're seeing currently. There is also an earlier webinar that Julia and I and our colleague Tim Johnson recorded related to the toolkit, which gives an overview of the work that Great Plant Moody and the Health Department have been doing as part of the Privacy, Security, and Health Information Exchange in Minnesota grant. The idea with the toolkit is that Great Plant put together a series of documents consisting of template agreements, flow charts, policies, and procedures, all of which are intended to be a foundation for compliance with various Minnesota and federal health privacy laws, things like the Minnesota Health Records Act, Minnesota Government Data Practices Act, HIPAA, and a number of other laws and regulations. Our thinking with the toolkit is that organizations can use the materials that we put together to add in the requirement standards that are relevant to their particular operations, remove some of the template language, some of the draft language that we've put together in the toolkit documents, and kind of tailor those materials for use at your own organization. Our focus in writing the toolkit materials has really been on healthcare providers. So, well, we recognize that lots of other kinds of organizations, such as health plans, have a real interest in privacy law here in Minnesota. Please know that the toolkit documents we put together are geared towards providers primarily. That's not to say that folks can't, use the documents that we've drafted and try and tailor them for your organization as you desire. We put these materials together with the hope that they'll be used on a fairly widespread basis. They're free of charge, and you can find them at the link that you're seeing here. A couple other things just generally on the toolkit materials that we put together. We do have to give a little bit of a disclaimer to say, that these are documents, they're general documents, they don't constitute specific legal advice for any particular organization. Folks using these materials will want to take them, think about how they work for your organization, and tailor them as you see fit. And in addition to that, we should mention that the specific topics that are addressed in the toolkit materials really come from some earlier work that Great Plant Moody has done alongside the Health Department as part of this grant. And that work involved a series of factual use cases that the department put together that raised various privacy issues. We took a look at those use cases, and we tried to isolate particular issues, particular fact patterns, scenarios that seem to be of common interest to providers in Minnesota, and we've drafted those toolkit materials to try and address those scenarios. We have, in some situations, tried to tee up alternative interpretations of Minnesota law and federal law. As listeners probably know, there are a number of different ways where you can interpret Minnesota law or federal law in different ways, and what we've tried to do is give a few examples of some of those different interpretations. The scope of the grant doesn't really permit us to address everything, so we want you to be aware of that as well. And finally, folks should also know that the toolkit is current as of the date it was published. Folks will want to think about whether they need to tailor that, tweak the materials as the law changes going forward. So what we're going to be doing today is we're going to be really going through one of our first substantive training sessions based on the toolkit materials, and that has to do with breach analysis. We're going to be doing a number of different webinars as part of our work in this grant. All of the webinars will be hosted on the website that you see here. You can also feel free to send Julia or myself an email at the email addresses listed at the end of the presentation and ask to be included on our mailing list. We'll be sending out announcements when different new webinars are available. I think we're doing at least 6 or 7 webinars going forward. And we're also going to be doing a series of in-person events related to the toolkit. We spoke recently at the Minnesota Medical Group Management Association winter meeting on the toolkit, and we have 3 other in-person events coming up, and you can see those dates and the name of the event here on this slide. So enough on the background. What we're going to be talking about today really is to try and dig down and get into sort of the nitty-gritty rules around breaches. I'm going to spend the next few minutes talking a little bit about the applicable law on the federal level in this area. So today we're really going to be focused on the HIPAA requirements for breach notification. Folks should know that Minnesota has a law in the Trade Practices Act related to what are called breaches of the security of the system that may also be relevant to your operations in some situations. And then the Minnesota, the Data Practices Act has its own provisions related to breaches. And if you do business in other states, many states, I believe most states actually, have their own version of a state-specific breach analysis law. Most of those laws, including Minnesota's law, really aren't specific to health care. So today what we're going to be talking about primarily is the HIPAA breach requirements, and I'm going to spend a few minutes on that. I'm going to turn it then over to Julia, who's going to go through some of the more recent enforcement actions that we've seen in this area, and then Julia and I are going to kind of go back and forth through a series of 6 hypotheticals that we've sort of laid out here as a teaser on this slide. And the idea with these hypotheticals is to try and raise common scenarios that might come up for providers and to help you understand how the breach analysis would work. So what are we talking about when we're talking about a breach? It's not quite as easy as you might think, and as you can see right here, our friend Max is very upset to learn about what's happening at the vet and Facebook, and we'll come back to Facebook in a little while. It's something of the bane of our existence when it comes to privacy, and in healthcare you certainly see that from time to time, as our hypothetical will sort of demonstrate. So what is the applicable law that we're thinking about here? Well, just a bit of the history on this. As listeners probably know, the HIPAA privacy law has been in effect going back to 2003, since April 2003. For a long time, from April 2003 till 2009, the fall of 2009, there really was no federal standard related to breach analysis or interpretation. There was a different concept in the privacy rule spelled out on this slide having to do with what was called mitigating harmful effects of a disclosure or a use of protected health information that wasn't permitted by the privacy law. Regulators, a lot of legislators, other people who pay attention to these kinds of things felt that that standard might not go far enough, and as part of the 2009 Recovery Act, the stimulus law, we saw the first federal standard with respect to healthcare breach notification, and that was part of the high-tech law. Now, everyone thinks of high-tech really as being about creating a standard having to do with meaningful use of electronic health records, and that's true. The idea, though, was that there was going to be a trade-off. If providers we're going to get financial incentives to buy and implement electronic health records in their practices, they were going to have to agree to a few things with respect to privacy. And one of the things they were going to need to agree to was to follow this standard related to breach notification. So the statute created its own standards having to do with breach. We saw regulations come out in 2009 in what was called an interim final rule. Many people in Congress thought that was kind of a weak approach. So it was on the books from 2009 to 2013, and then in early 2013, we saw what was called the high-tech omnibus rule, which basically just means a big series of regulations having to do with all kinds of different components of HIPAA. And the omnibus rule addressed the breach notifications in terms of some of the changes. So how does it work? There's really sort of a general concept where we start from. The idea here is that covered entities are required to provide notification to individuals if there's a breach of their unsecured protected health information. Business associates are supposed to notify the covered entity. The covered entity is supposed to notify the Department of Health and Human Services, and both covered entities and business associates are required to comply with all of these standards. So the key to this, the key to understanding this general kind of concept having to do with breach really is digging into the definitions here. What constitutes a breach? What constitutes unsecured protected health information? The definition of breach that we're working with currently under the 2013 rule really has to do with the disclosure of protected health information that isn't permitted. Basically, a use or disclosure of PHI that doesn't comply with the privacy rule. The 2009 definition of a breach focused on whether an incident created what was described as being a significant risk of harm to the individuals involved. The final rule removed that risk of harm standard, and now what we really have is this concept of an impermissible use or disclosure of unsecured protected health information is presumed to be a breach unless the covered entity or business associate is able to demonstrate that there's a low probability that PHI has been compromised. So we're going to go through some of these terms in a minute, but really it's thinking about this concept of a presumption of a breach and whether you can overcome that presumption of a breach. That was a significant change in the 2013 version of the law as compared to the 2009 version of the law. Now, there are still a few exceptions to the definition of a breach. These stayed the same with respect to the breach notification rule. Basically, what each of these exceptions you see here on this slide has in common is that all of these things really are about mistakes. They're not about purposeful conduct. They're really about unintentional conduct. So I'm not going to spend a lot of time going through the details of these. They'll come up a little bit in our hypotheticals later. So under the final rule, we have this low probability issue to deal with. So the first question really is, okay, if we have a use or a disclosure of protected health information that doesn't comply with the privacy rule, then we're in this scenario where we have to think about whether the presumption that results from that use or disclosure that doesn't comply with the privacy rule, whether that presumption can be overcome. And the way the regulators want us to do this is by thinking about 4 different factors. And you kind of see these 4 factors here. Basically, the government is saying you want to think about the nature and extent of the unsecured protected health information at issue, the unauthorized person who used the information or to whom that information was disclosed, whether we know that information has been actually acquired or viewed, and the extent to which the unsecured PHI has been mitigated. Now, these factors are spelled out in the regulations themselves. The guidance from the Department of Health and Human Services makes clear that organizations should be thinking about other factors if those factors are relevant. to the analysis, but you want to think about these factors at the kind of a minimum in determining whether you can overcome the presumption of a breach that results from impermissible disclosure or use of PHI. So if we do have a breach, what's supposed to happen? Well, the regulations spell out a process that they want covered entities and business associates to follow. Basically, the idea here is to provide notification of the breach and to do this in a couple different ways. Individuals need to get notification. The media may need to get notification if we have more than 500 people in a state or in a geographic jurisdiction affected. Health and Human Services, HHS, they need to get notification. The timing, though, for the HHS notification is going to depend on how many people are involved in the breach. If we have more than 500 people affected by the breach, the regulations indicate that notice is supposed to go to HHS at the same time as notice is going to individuals. If you have fewer than 500 people, then what needs to happen is that notification goes to HHS annually. Basically by March 1st is the deadline that they've indicated they want folks to use. Now, business associates, their job really under the regulations is to give notice of the breach at the business associate to the covered entity. Now, one thing to know when you're a covered entity dealing with business associates is that all of these things spelled out here in terms of who is giving the notice, that they can be changed by the business associate agreement. So some business associate agreements might indicate that it's actually the business associate who will be giving notice to the individuals as opposed to the covered entity. That's kind of a business decision for folks in terms of who is doing what under the business associate agreement. The important thing, though, from the covered entity's perspective is that you really have to make sure that the required notices happen. So, trying to contract it away, contract the responsibility away to someone else isn't going to get the covered entity off the hook from the regulator's perspective if the notice doesn't actually happen. So you need to be thoughtful about what those business associate agreements have to say in terms of this kind of work. Health and Human Services, they publish a list of these breaches on their website. We have a screenshot of that a little bit later for folks to look at. As you'd expect, there are some timing deadlines for parties to follow in terms of giving the notices required when there's a breach. Basically, the regulators want this to happen without unreasonable delay. They say that you have no later than 60 calendar days following discovery to do the notification, but you're not supposed to just wait out the 60-day period and then give the notification. We'll come back to this point about the burden on the covered entity to demonstrate compliance with this requirement, because it is an important step that you don't want to skip over. One thing to know is that there are a couple of ways you can get a delay in notification. If law enforcement, for example, requests that happen due to an investigation of the facts at issue in the breach, there's some discretion to have a delay. So you can look at the regulation for more details on how that works. In terms of the notice themselves, the rules go through in fairly specific detail exactly what needs to go into the notice. You can see that spelled out on this slide here. There's also a little bit of leeway depending on whether we have, lack of accurate contact information for individuals. If there is insufficient or, dated contact information, then there are a couple different options for giving notification to the individuals at issue. It really depends on how many people are involved. Fewer than 10, you have one way to do it. If you have more than 10 folks affected, then what really the idea with the requirement is that they want you to be putting out a broad notice that's likely to get people's attention. Major print or broadcast media is one option for doing that. And again, there's more detail in the regulations themselves. The substance of the notice, as you might expect, the rules go through a fair amount of detail about what must be included in the notifications. The slide that you're looking at currently talks about a number of those different things. All of these items are factors that a covered entity needs to make sure are addressed in the notification that individuals receive. Now, this doesn't mean you can't have other things in the notice, and you'll sometimes see some of the notifications that come out will talk about other things that you don't see here. So, for instance, you know, contacting credit monitoring companies, getting credit reports, putting credit freezes on a person's account. All of those things kind of fall within this point about, you know, what the kinds of things that individuals might want to do to protect themselves from potential harm resulting from a breach that you see kind of in the middle of the slide here. So those sorts of specific details you'll often see in these breach notification letters. Other letters will sometimes reference what a covered entity might be doing in terms of contacting state regulators, which is something that you sometimes see under the state breach notification laws, or some states will say that you know, that they want regulated parties to also give notice to consumer reporting agencies. So there are other things that can go into the notice, and HIPAA will permit that as long as you address what's required under the regulation. So, you know, when this happened in 2013, the commentary and the regulations kind of, you know, sort of gave the impression, in my view at least, that this kind of resolved things in terms of, you know, what constitutes a breach and kind of putting an end to some of the debate that's out there about what's a breach versus what's not a breach. The idea behind the 2013 standard that we've been talking about so far today is that it's supposed to be a little bit more objective than the 2009 standard, the risk of harm standard. Apparently, in Congress, there was some concern that the 2009 standard really wasn't creating enough of an incentive for parties to give notification of breach. Folks in Congress, at least a few of them, believe that organizations looked at that and just kind of were, you know, coming to the decision that no, we don't really think that much risk of harm really is present here, so we're not gonna treat this as a breach. And the 2013 change really kind of flipped that around, because now, due to the presumption of a breach that comes out anytime you have a use or a disclosure of this unsecured protected health information that you're stuck with, the presumption that you're stuck with, organizations really are in a position where they kind of have to default to things being a breach, which at least raises the question of whether some of this is going to be a bit of white noise for individuals, because if people are receiving notifications regularly or more often than regulators think, there's at least some danger that it might get a bit drowned out because organizations are just kind of defaulting back to that presumption. So, you know, the positive of that is folks will know what's going on. The potential negative of that might be that people, you know, may not be learning of all the details about what's happening here. So I don't know that the 2013 standard that was created really answers all of the questions in quite the way that the Office for Civil Rights hoped that it would. I think there still is a lot of subjectivity associated with this analysis. So how do you prepare for breaches? What kinds of things do you think about in terms of tackling the issues that are likely to arise at your organization? As we're going to start talking about now, there's lots of guidance from OCR about the kinds of problems that have come up for covered entities in the past, and a lot of what you'll see from the OCR guidance kind of gives you starting points or hints, the kinds of things that you should look to at your organization, at least to as sort of a high-level question about, you know, what are we doing around our business associates, for instance? What are we doing around our portable devices, our laptop computers, the kinds of things that present risks of breaches based on past guidance from the Office for Civil Rights. So regularly reviewing what the OCR has to say about risks and vulnerabilities in privacy is a great idea. The OCR has lots of updates that they send out if you want to sign up for that information, and you can learn about some of the enforcement actions that are happening. You can also learn about areas that OCR points to as presenting potential problems for folks. And you'll see some of the tips for doing that on this slide here, addressing risks and vulnerabilities. The third bullet point down that I mentioned that says thoroughly document assessment, that's something that folks should really pay attention to anytime you have a breach analysis. As I mentioned before, there's this burden under the regulations to maintain a record of how you analyze the situation. And what's going on here is that covered entities, business associates, if they're finding that an unsecured disclosure, an impermissible disclosure of unsecured PHI really poses this low probability that the PHI has been compromised, it's important to keep your analysis of how you got to that view, because what can happen is some of these situations are very fact-specific. Some of these situations, different people can disagree, and those disagreements can reflect very reasonable positions. Things aren't always as clear-cut as we want them to be. So an organization that's deciding, we don't believe that what's happened here actually is a breach, that may be the right answer. But if you're not able to demonstrate to the regulators, if you need to demonstrate to the regulators why you reached that conclusion, that's not going to convey to them that you're taking things as seriously as they want you to. So keeping your analysis, keeping a record of it, and being able to prove that up when you need to is important, particularly considering that there's always the chance that someone at your organization may disagree with your analysis. There's always the chance that a patient might file a complaint related to what happened at your organization, so it is an important step. And then thinking about your policies and procedures related to breach analysis is also very important. One of the best ways to think about and understand where the Office for Civil Rights and other healthcare enforcement agencies are going in terms of enforcement is to pay attention to the studies that they conduct and the results of those studies. And earlier, back in 2016, Office for Civil Rights put out a study related to whether or not covered entities are prepared to respond to privacy and security incidents. And OCR's study found that 55% of the respondents that they surveyed lacked any incident response team at all, so they didn't really have a group of people designated as tasked with reviewing, analyzing, tackling issues associated with breaches, and 43% of those respondents not only didn't have a team to put together to address those things, but they didn't have any policies or procedures at all related to any kind of breach analysis. So those organizations, if they're confronted with a situation such as somebody posting protected health information on a social media site like Facebook or Twitter, or an organization that loses a laptop or emails PHI to the wrong person, those kinds of bad fact patterns that can arise through the use of some of the technology we have, they don't really have the infrastructure on hand to be able to address and analyze those issues. So those kinds of things, having policies and procedures, having a team ready to go who's hopefully trained on these issues is a really helpful way of getting in front of some of the compliance problems that can come up. A few other things here. If you're dealing with business associates, that's a really important one because business associate agreements, a lot of them have been around since 2003. Some of them may not have been amended since 2003, even though technically they needed to be amended back in 2013. Some listeners may be dealing with business associate agreements that never were changed. And those business associates may take very different approaches on how breach analysis is going to work. So you want to be sure you understand what your business associate agreement says, who's responsible for what, does that make sense for your organization, should you amend that, should you try and change that to put into place a different process, is an important thing to think about. And if you're a business associate who's listening to this presentation and looking at these slides, it's an important thing for you to think about as well, because not only will you have responsibilities to your covered entity contractors, but you also might have subcontractor business associates that need to report things to you. So you want to make sure that your contracts with your subcontractors make sense, and you want to evaluate whether they sync up well with your contracts with covered entities. So looking at all of these things, training on all of these things is a very helpful way of getting ready for breaches. Insurance and indemnification, we could do a whole hour just on those topics, so I'm not going to say a lot about this other than don't just assume that your insurance policies, whether it's general liability coverage, whether it's D&O coverage, that they apply to HIPAA breaches or potential HIPAA breaches. There are policies being written specifically for these kinds of things. If that's of interest to your organization, you want to think about that and you want to talk about with your broker what's out there and what might make sense for you, but don't just sort of fall back on the general insurance that you might have and assume that it's going to address these issues. And then finally, with indemnification, a lot of times business associate agreements will have provisions buried in the contract, often towards the back where the business associate really is promising to indemnify the covered entity for what's happening. The covered entity needs to understand that that might not be worth all that much if the business associate doesn't have the resources to cover that responsibility. And the business associate who's signing that kind of provision, you just want to be thoughtful about what you're agreeing to exactly there, because the costs associated with looking into a breach, with investigating, with responding to a breach, particularly if we're dealing with patients located in multiple states or covered entities that do business in multiple states, it can get pretty expensive pretty quickly. So insurance and indemnification can be very helpful in this area, but don't just assume that because it's mentioned in a business associate contract that there's protection for the parties, because that might not be the case. So with that, I am going to leave you for now with the intimidating picture of Horatio Kane from CSI Miami and turn it over to Julia, who will talk about enforcement.
Great. So we spent a lot of time talking at this point just about what the HIPAA breaches are and the legal rules that govern them, but equally important to this conversation is understanding the penalties that providers face when they encounter problems or issues or otherwise just make mistakes in this area. So the U.S. Department of Health and Human Services Office for Civil Rights, OCR, is responsible for enforcing HIPAA privacy and security rules. OCR enforces this by investigating complaints and conducting compliance reviews of alleged violations. And we're going to just spend a little bit of time talking about some recent enforcement actions and what an OCR investigation will look like. So as this bar graph illustrates, OCR receives more and more complaints every year. So in 2015, OCR received over 17,000 complaints, and if you go back and you look at how many were filed in 2013 or 2014, it's a significant increase. And as OCR, they can do a number of things once they get a complaint. Generally, though, the first thing that they're going to do is just make sure that they have authority to actually investigate. So they're going to conduct what's kind of called as an initial intake review to make sure that they do have authority to dig in deeper. So, for example, if OCR determines that the alleged organization that has made a HIPAA violation was not a covered entity or a business associate, they're just going to simply close the case at that point. But once this hurdle is cleared, OCR then moves forward and actually conducts and investigates and looks into what the alleged violation was. So this chart that we're looking at now, this bar graph, shows a comparison of the complaints that OCR has closed by calendar year according to the type of closure. So as I mentioned earlier, there was over 17,000 complaints filed in 2015, and that's represented by in this group of 5 graphs here, the farthest one to the right. So the very orange column, that just represents how many complaints were actually filed. But what gets interesting is when you start looking at how the types of closures compare. So the very first column, the blue one, this represents complaints that were closed where OCR found no violations. So this is things where they actually investigated and they just concluded that the organization followed protocol, they did everything right, and there was no HIPAA violation at all. And as you can see, this is the smallest the smallest category of closure. If you go to the very next one, the second, or the yellow column, this represents those cases that have resulted in a corrective action plan. So this is essentially just an agreement between OCR and the organization, where the organization decides or agrees to actually make changes to their HIPAA compliance programs and their protocols to take into account those things that OCR concluded were insufficient. So this happens a lot, as you can tell, and we're going to talk about these corrective action plans in more detail later on. The third, the green column, represents those complaints that have, after intake or after review, they've simply closed them. So this includes those instances where I mentioned that OCR has decided that they don't actually have authority to look into this. So it's slightly more than those in which they've concluded there was no HIPAA violation, but still relatively small. Lastly, the fourth, or the purple column, represents those cases in which there was a technical there was resolved after there was technical assistance. So why I'm spending so much time on this, and what I find to be interesting, is just the takeaway that it's very rare for there to be, for OCR to conclude that there has been no HIPAA violation. And when you're thinking about HIPAA breaches and when you're considering what to do, I would think twice about just ignoring it, because the reality is OCR actually ends up uncovering a lot of other things that they think organizations do wrong once they start investigating. So the chances of this just going away, or the chances of it kind of falling into the background and not being something that you have to deal with are very small. What you don't see in this slide is also how often there are financial penalties in this area. So we're going to spend some time talking about that, but that can be a big issue as well. So after you start looking into some of the things that OCR is doing and the things that they're focusing on, you can start to see a pattern in those that are investigated and those issues that are most problematic. So this lists in order of frequency the types of investigated issues. So at number one, we have impermissible uses and disclosures of PHI. So this is going to be your kind of classic breach scenario. We're spending our presentation today talking about this exact one. It is the most frequent and the most important, but you'll see that there are certain other issues that you can encounter and your organization may have to deal with. You can also start to look at the types of covered entities that are required to take this corrective action, and look at the patterns and assess where your risk may fall. So at number one, again, this is an order of most frequent, we have private practices, and then general hospitals and outpatient facilities, second and third, respectively. So we're just going to spend a little bit of time talking about some recent enforcement actions, because they do shed light on the types of issues that providers are struggling with and the issues that OCR is focusing on and their reaction to them. So the first one that we're going to talk about today is the Memorial Healthcare System enforcement action. So MHS is a nonprofit corporation that operates 6 hospitals, an urgent care center, a nursing home, and a variety of other ancillary healthcare facilities throughout South Florida. They're also affiliated with physician offices through an organized healthcare arrangement. On April 12th of 2012, MHS submitted a breach report to HHS that indicated 2 employees inappropriately accessed patient information, and that included names and dates of birth and social security numbers. So MHS looked into it, they did this kind of initial investigation, and they actually discovered that unfortunately there had been additional breaches. So they uncovered that a former employee's login credentials had been used on a daily basis to access PHI, and this went on undetected for a year. So they ended up submitting a supplemental addendum to their breach report, and that happened on July 11th of 2012. So OCR started their investigation, and they looked into everything, and what they uncovered was that this breach incident was actually pretty significant. So over 115,000 individuals were affected. And to make matters worse, some patient information was actually sold and some was used to file fraudulent tax returns. So when you take those into account, in addition to the fact that this happened with such a prolonged period, there's a lot of bad facts for this one. So Interestingly, MHS did have a workforce access policy and procedure in place, but what OCR concluded was that they failed to implement this policy. They determined that had MHS actually been following it and going in and performing some of the audit requirements that they were supposed to do and make sure that everybody who was actually accessing PHI had authority to do so, if they had done that, then this prolonged year period of unauthorized access would not have occurred. In addition to this, OCR actually concluded that MHS failed to regularly review these records when they had identified this as an area of risk in their risk analysis that they performed in 2007 to 2012. So ultimately, MHS agreed to a $5.5 million settlement, and then they entered into a corrective action plan to fix some of these areas. And you know, when I'm thinking about this issue in this case, I think the most important thing that we should be thinking about is just how important it is to actually be performing some of these things that are in place through HIPAA. So, for instance, as I mentioned, had MHS actually reviewed their audit logs as their policy said that they would, and as they are in fact required to do, they would have caught this issue earlier on, and I suspect that the actual settlement would have been less, and the corrective action plan requirements would have been a little bit easier to follow. But the second lesson is an important one as well, and that's that when you're conducting your risk analysis and you're thinking about the types of things that place your organization at risk for HIPAA issues, it's important to do that step, and it's required, but it's just as important to follow through on this. And so I know Jesse and I talk about this a lot when we're counseling other organizations, but you can't just have kind of your standard HIPAA policies on a shelf and they're covered in dust and you never look at them. They actually need to be something that you're implementing and that you're using. And the same is true for your HIPAA risk assessment. So regulators really don't like it when they see that you've identified a risk and have all these plans to do something about it, but then you fail to follow through on that. And that was something that OCR really highlighted in this enforcement action. And something that really stands out as a lesson to be learned. So the second one is Presence Health. This one is a little different. Presence Health is one of the largest healthcare networks, and it serves Illinois. It consists of approximately 150 locations and includes 11 hospitals, 27 long-term care and senior living facilities. And they also have multiple physician offices and healthcare centers in the system. So on October 22nd of 2013, Presence discovered that their paper-based operating room schedules were missing from their surgery center. These schedules included patient information such as names and date of birth and medical record numbers, dates of procedures, that type of thing. The wrinkle in this case is that Presence did not report this breach to OCR until January 31 of 2014, which is 101 days after they were found to have discovered the breach. So OCR ultimately concluded that Presence failed to comply with the notification requirements, which, as Jesse mentioned earlier, require organizations to report within 60 days of discovery. So it's very interesting because this is actually the very first HIPAA settlement case that's based on the untimely reporting of a breach. So it shows that OCR is actually looking at this and they're actually making those conclusions that a breach was discovered on X of a date and it was reported on X, and that you can actually get dinged for not complying with that 60-day time frame requirement. The next one here is Care New England Health System. So Care New England, this case is important as we're going to discuss. It talks about the importance of business associate agreements, which is something that it keeps coming up again and again. So CNE provides centralized corporate support for its subsidiary affiliated covered entities. So it includes a number of hospitals and healthcare providers in Massachusetts and Rhode Island. They do things like finance, assistance, human resources, information services, technical support, kind of a variety of different administrative functions for these covered entities. So CNE was actually a business associate of Women and Infants Hospital, Rhode Island, WIH. And this breach actually results from something that happened with WIH. So they had approximately, I don't know how many backup tapes, but they had a loss of unencrypted backup tapes that contained ultrasound studies of approximately 14,000 individuals. And so this included patient information like names and date of birth, date of exam. There were some social security numbers involved. But the issue in this one is, although they had a business associate agreement in place, the effective date of the agreement was March 15th of 2005, which means, unfortunately, that this business associate agreement did not incorporate the revisions that were required under HIPAA for the omnibus final rule. So they did end up amending it as a result of the OCR investigation, but OCR concluded that the business associate agreement that was in effect when this breach had occurred was outdated and did not include all the necessary requirements that were mandated. And so, in fact, there were impermissible disclosures to the business associate. What's interesting here is the WIH actually entered into a consent judgment with the Massachusetts Attorney General, and they reached a settlement of about $150,000. OCR did just talk about the fact that they decided not to include additional penalties, and the reasoning behind this is they didn't want to undermine the authority of the state attorney general, and so they really didn't want to step into what was happening and the agreement that was reached. But what happened then is C&E ended up dealing with OCR for this same issue, and they reached a settlement of $400,000, which is significantly more than what was reached for the covered entity. It's a good reminder that business associates can be directly liable, and they are directly liable under HIPAA, and OCR will actually take action against them when they don't comply with it. So it's an interesting recent enforcement action in that regard. The last one we're going to talk about today is the Advocate Healthcare Network. So in 2013, Advocate submitted 3 breach notification reports. There were a number of violations in this, which included failure to conduct a risk assessment, failure to implement policies and procedures to limit and protect access to PHI. They failed to obtain satisfactory assertions from their business associates, and then they failed to reasonably safeguard unencrypted laptops. So the lesson from this action is that it's never too late to revisit and improve your HIPAA compliance efforts. Advocate entered into a $5.55 million settlement and a corrective action plan, and this is the largest settlement to date against a single entity. In large part, the reason for this significant settlement amount is because of the extent and the duration of Advocate's noncompliance. So OCR noted that some of the noncompliance issues dated back to the inception of the security rule. It's a good reminder that just as OCR takes positive actions into consideration, such as mitigation efforts, they also equally consider when an organization fails to act and when that becomes a prolonged and very significant time frame. So this slide here, we just wanted to show you that you can actually look up these breaches. So as Jesse mentioned, breaches that affect 500 more individuals are required to be reported within that, to HHS within that 60-day time frame, and they actually are posted online. You can access them through this link that we've included here. Here what I've done is I've just sorted so that you can see some of the recent enforcement actions that have happened in Minnesota. So when you go to this link, you're going to see a very large, long list of the recent breaches. You can sort based on state, and then you can also sort based on submission dates. So you can get a sense as to what's happening in your area right now. What's interesting on this slide, though, is if you go back to 2009, you'll look at the type of breach that happened, and it was overwhelmingly kind of the classic thefts, the theft of laptops, the loss of information, that type of thing. Most recently, we're seeing more and more of the hacking and the IT incident occurrences, and this is becoming a big risk area for organizations and something that a lot of organizations are starting to have to really think about. And you'll see that more and more when you start sorting based on breach submission date, that this is really becoming a big issue. So we're going to change gears a little bit and actually get into some of the fun stuff. We're going to talk about some case studies, and we're going to actually use this as an opportunity to walk through a breach analysis and highlight some issues that we think you should be thinking about when you're encountering some of these troublesome areas. So the first one we're going to talk about is case study 1, the misplaced files. So here we have a pediatric group that is transitioning to EHRs, and they want to purge all their paper charts. There were several boxes of charts were unfortunately mistakenly placed by the recycling bin behind the clinic, and in this process a passerby sees the boxes and they post photos of these boxes and some charts to Twitter. So the first thing that you should do when you're thinking about this is try to determine if there is a breach. So remember, impermissible use or disclosure is presumed to be a breach unless the covered entity can demonstrate that there is a low probability that PHI was actually compromised. So the covered entity does have the burden to prove this low probability based on those 4 factors that Jesse talked about earlier. So we're just going to walk through them briefly. So the first factor is the nature and extent of unsecured PHI. Here, the charts likely contain a lot of sensitive information, a lot of PHI. They probably contain medical records and names, patient names, birth date, social security numbers, that type of thing. So the fact that the nature of these charts are so sensitive kind of weighs against this factor, and I should say weighs in favor of it being a breach. The second factor is the unauthorized person to whom unsecured PHI was disclosed. The issue in this example is it was posted on Twitter, so it was posted on social media, which means that it was very, very likely to have many viewers over the internet. So this weighs in favor of it being a breach. The third factor is whether unsecured PHI was actually viewed. I don't know that we know that they were actually viewed here, but it's very likely that they were, just based on the nature of Twitter and based on all these social media things that are just kind of blasted to everybody and available without any sort of constraints on it. So it was very likely that it would have been viewed. Finally, the fourth factor is the extent to which risk was mitigated. Here, maybe the covered entity could have taken those charts once they were discovered to have been left in the wrong place, and they could have shredded them, but unfortunately, once they're posted on social media and once they're on the internet, they're kind of out there, and there's really nothing you can do to kind of get them back. So it's going to be pretty challenging for the covered entity to really, truly mitigate the harm from this. So after kind of thinking about these factors, I think for most of them, they weighed in favor of them being a breach, and in fact, we would conclude in this case, just based on these limited facts, that there probably was a breach, which means that notice is required. So the covered entity, the organization, would have to give notice to patients within 60 days of this discovery. If it involved more than 500 people, they must simultaneously notify HHS and the media. What's interesting, and just to kind of flip the facts a little bit, is does the answer change if boxes simply disappeared and we don't know for sure if they were posted online? And similarly, if they learn that they're sitting outside, they go out and they collect them, and then maybe they were taped and secured and wrapped in plastic, and you could tell that they had not been opened. Does this change the facts a little bit? And in fact, I think that it does. It really kind of impacts the second or the fourth factor, mitigation. So if the staff member can retrieve the box and it's clear that they have been unopened and they can actually shred them and properly dispose of them, you can, number one, say that you've done a good job mitigating the risk, and you can also probably say that there was a very, very low probability that the PHI was actually viewed. So that helps with our third and our fourth factor. Because of this, it's also likely that you can, for the second factor, it wasn't really disclosed to an unauthorized person. So I think that would change the facts a little bit, and you may be able to conclude that there was not a breach.
Okay, thank you, Julia. So moving on to our second hypothetical, a lost laptop, something that is pretty easy to relate to. So the thing here is we have a neurologist. She sees patients at the local hospital, has patient information on her computer, her laptop computer. That information has names, diagnosis information, prescription information, medical history information. It doesn't have financial information, though, so we don't have social security numbers, we don't have credit card numbers, that kind of thing. The neurologist leaves the laptop on a bus. It's not recovered. And our hospital here does not have an encryption policy. So how would this case be analyzed? Well, so the first question in thinking about this really is, do we have the kind of impermissible use or disclosure that creates the presumption that we need to deal with? We don't exactly know based on the facts because, the facts that we have indicate that the hospital does not have an encryption policy. It is possible that there may have been something on that computer to try and secure the information in a different way. So, for example, did the neurologist have her own encryption software on the computer? Or is there any kind of password, username, log-on information that would be needed to get access to see what's on the computer? Or even better than that, if getting on access to the computer required logging into a network where you'd need some type of dual-factor authentication, so a username, a passcode, and your own personal password to log on to that information. Those kinds of things, and then also, if the information at issue didn't really reside on the laptop hard drive, but instead rested at the hospital's in the hospital's information systems, those kinds of facts that we don't really have, that they, potentially if they existed, could change the analysis. But if what we're talking about here is really a laptop computer, no login, no password, patient information sitting on the hard drive, and the computer is simply, just lost or stolen or disappears on the bus, then I think we probably do have a disclosure of PHI that's not permitted under the privacy rule because the computer is basically gone. So now we have to think about our four factors that we've talked about a little bit. Well, we don't have financial information. That's helpful. Because that, is always going to make the information, quote-unquote, sensitive from an objective standard. But we do have detailed information about our patients here. We have things about the types of prescriptions that they take, what kind of diagnosis they have, their medical history. All of that is going to be considered fairly sensitive information. We don't really have great answers to the rest of the questions in the breach analysis. We don't know necessarily the answer, but we don't have great answers. So we don't really know if somebody stole the computer or if somehow it just vanished, ended up in the trash, was destroyed. There is a possibility that no one actually saw the computer, and there's certainly a possibility that no one turned on the computer and went to the trouble of poking around on the hard drive and figuring out where exactly the patient information is located. That may or may not have happened. We just don't know. So the second and third factors in the analysis were kind of really flipping coins in terms of trying to figure out exactly what took place there. Our final factor, what kind of mitigation is relevant to the information at issue here? Well, we really don't have a lot we can point to in terms of mitigation because the computer just disappeared. The neurologist doesn't have much that she can do to try and get the computer back. One of the ways to understand how situations like this might be analyzed would be to think about whether there are similar situations that have come out in the past in terms of HIPAA enforcement. We did have an earlier enforcement action, I think this one is from 2013, relating to an oncology group that had a laptop computer that was unencrypted. The information on there consisted of about 55,000 patients, and the computer was stolen, and that information was accessed. request. And in that scenario, the cancer group reported what occurred to HHS, and there was an investigation and a fine imposed against the cancer care group. And the settlement agreement there, or the resolution agreement there, pointed to some problems that the cancer care group had in terms of privacy compliance. And, you know, in a situation like that, we were looking at some facts that weren't all that helpful, because the group at issue in that scenario hadn't, according to OCR, been addressing HIPAA in quite the way that OCR felt was necessary, and that resulted or led to a fairly large fine. Now, our facts don't point to those, or they don't give any indication of those types of additional bad facts. We just have the computer that vanished, and we really don't know much of what we can do to try to tie out these questions about whether anyone actually viewed the information at issue, or what, you know, the sort of ultimate disposition of the laptop, what it was. So because of that, because we don't really know answers to factors 2 and 3, and there's really nothing we can do in terms of mitigating the breach, we are probably in a situation here where the regulatory presumption of a breach is going to be challenging to overcome. If the neurologist is sitting down to do this HIPAA breach analysis and documenting the results of that analysis, it'll be challenging to point to the kinds of factors that we've been talking about as a way of overcoming that presumption. Now, one of the interesting things about this scenario is that depending on the facts, we may have a bit of a debate about who actually is responsible for the breach here. The facts indicate the neurologist sees patients at the hospital, but you know, we don't necessarily know if the neurologist has her own practice, if this computer is going to have records of patients who were just the hospital's patients, or whether they were whether the patients were patients of the neurologist in her independent practice. We don't know whether she was functioning as part of the hospital workforce, or just in terms of her own separate practice, separate covered entity that she runs. We don't know whether there were policies and procedures at her practice that she wasn't really following in terms of what should be on this laptop versus following the hospital's policies and procedures in terms of what the security on the laptop. So there are some twists here depending on those kinds of issues, the relationship between the hospital, the neurologist, who's the covered entity here, whether they were operating as part of an organized healthcare arrangement in the delivery of care, whose patients were at issue here, and those kinds of questions will really drive the answers to who is really responsible for this breach here. And then thinking back to the cancer care group example, where OCR found widespread noncompliance with the security rule for that group, which resulted in penalties that were a little bit higher than you might normally see. If we have those kinds of factors at issue for our neurologist or our hospital, you might see a higher penalty level than would normally be imposed for this fact pattern.
Okay, so case study 3, which is the break-in. So this is kind of a slightly twist to the one that Jesse just talked about. Here we have an employee at a health plan who has access to health records, and they have a sticky note on her laptop with login information. The employee's laptop is stolen from her home as part of just a routine break-in, and importantly here, the laptop uses single-factor authentication, just the login and then her password. So based on these, you can see that the person who stole her laptop would be able to just look at that sticky note and actually just type right in all you need to know to have direct access to any information that would be on that laptop. So the first question here, is there a breach? So when we're walking through our 4 factors, it's very likely that there's some sensitive information because a lot of the PHI is likely going to be available in the health plan system. So knowing that, just the nature and the extent of the information that would be available would likely be pretty sensitive. But what we don't know is who might access it with the stolen credentials. I mean, it could be somebody with malicious intent based on the fact that they broke into her home and stole her laptop. It could be somebody who has absolutely no interest in what's on that laptop, and maybe they just have a desire to sell it to the next person and not actually open it or bother looking to see what's inside for information. So for this particular factor, we really don't know. The third one, there's also no indication based on the facts that we've just gone over that it was actually viewed or anybody actually looked at or opened or logged into the laptop. So probably the most important question then is the final factor. Can the organization quickly mitigate the loss by changing the employee's login credentials? So this gets to that mitigation. Is there an ability to on the other side, do something fast that would prevent anybody who stole it from actually logging in? This is really where our breach analysis turns. So we want to know more information. How quickly did the employee discover and then report the theft? Was this something that they, walked in an hour after work and they uncovered and reported it right away, or was it something that they were gone for a week vacation and had no idea and it went on unreported? The other very important thing is what kinds of access controls are maintained by the organization. So does the organization actually have the ability to go in remotely and change her username, change her password, lock out anybody from the outside from actually accessing it? Do they have that kind of technical ability? And third, the other question that we'd want to know is how quickly the organization, the covered entity, can respond to that report. So kind of in conjunction with the first question, how quickly was it reported, do they have a system in place and individuals who are equipped and ready to take action in this kind of a situation? So the security rule does require covered entities to implement procedures to review system activity. So technically the covered entity should be able to go in and review the audit logs and their access reports and really look to see if somebody has actually logged into that computer using this username and password. So if the organization is compliant with some of these requirements, they really should be able to determine if there actually was an unauthorized access of PHI after the theft. They also are required to kind of have the ability to terminate access controls and change them after employment and that sort of thing. So they should have the ability to change passwords and usernames and prevent somebody from actually going in and accessing it. So if an organization does have that ability, if they can actually go in and look to see that nobody's accessed or viewed the PHI, and they can actually mitigate any future access by changing usernames or the passwords, then there would be the ability to probably create a rebuttable presumption that there was not a breach.
Okay, so our next case study involves a consult that has gone wrong. So what's going on here, we have a family medicine physician at a clinic seeing a patient, and during the course of that consult, the family medicine doctor thinks, uh-oh, it looks like there is a skin blemish here that might be potentially troublesome. So the doctor decides, I'm just going to take a picture of this with my phone, and I am going to text a photo of this blemish to a dermatologist. I know we work with them from time to time. The dermatologist is at a different clinic, and hopefully get a quick consult on what's going on with this case. So our doctor snaps the photo, texts it off, problem solved. Unfortunately, the problem actually just got started because the photo went to the wrong person. The physician at issue at the family medicine clinic ended up, falling prey to autocorrect, and the photo went not to the dermatologist, but instead to a radiology technician that our family medicine doctor knows, who happens to have the same last name as the dermatologist, but who works at an unrelated imaging center. The radiology technician doesn't know anything about skin blemishes or how to treat them or what they are, really, and really has no connection whatsoever to patient care or this particular patient. However, the technician does know the physician who sent the photo. So how do we analyze a situation like this? Well, one of the things that we haven't really talked about so far is this question of whether the PHI at issue is unsecured. That's kind of a different topic, more of a HIPAA security rule type of topic, but the point of it for purposes of this scenario is that listeners should understand that if your protected health information has been secured in accordance with guidance that you can find on the HHS website, you will have secure PHI, and the advantage of that is if you are dealing with PHI that is secured and that information goes to the wrong place, then we don't really have to worry about breaches, because the thinking is that your protected health information has been secured in accordance with standards that HHS has said are sufficient based on guidance from the National Institute of Standards and Technology, who publishes guidelines in this area. And if you're dealing with security at that level, we don't really have this problem, because there really isn't a danger based on the NIST standards that anyone can see what's in the file. It's simply secured to a sufficient degree. We're kind of ignoring this question about secured versus unsecured PHI in these hypotheticals because it's more interesting and probably more helpful for you if we're thinking about this in terms of unsecured PHI. So in our scenario here, we're just going to assume that our doctor, our family medicine doctor, wasn't using any kind of virtual private network-based texting for this photo. He was just essentially sending it through his text messaging services on the phone. So our second question then is, well, okay, do we have a disclosure that violates the privacy rule? Because after all, he was really trying to share the information with another physician for treatment purposes. And, you know, you might be able to look at this kind of fact pattern and say, well, you know, the privacy rule does give a covered entity the permission, the ability to disclose PHI for treatment to another covered entity, and perhaps that's what's going on here. So that, you know, that might be one way to take a look at this scenario. If that is not the analysis, though, that you're going to be using, the next question would be whether we are in a situation where we can rely on one of the exceptions that I talked about at the beginning of the presentation to the definition of breaches. As I mentioned, you know, those exceptions really are based on mistakes. And this does seem like it's been a mistake, right, because it simply went to the wrong person. And we're pretty close to the exception for disclosures. The challenge, though, in qualifying for that exception is that the impermissible disclosure exception to breach really is about disclosures within the same entity, and this is a situation where our provider, our family medicine doctor, sent the PHI to a totally unrelated entity, so I don't know that we're going to necessarily fit into that exception. But what about the breach factors, right? Because this does seem a little bit different than some of the other facts that we've been dealing with. So in terms of the things we've been talking about so far, you know, the photo is you know, of what's going on with this patient. You know, is that sensitive or not? That's kind of debatable. But if we just, you know, stipulate for purposes of the hypothetical that it is considered sufficiently sensitive, that you know, an objective analysis would be that it creates issues, we then need to move on to the other factors in the analysis. And what's helpful here from this perspective is that you know, our recipient is somebody who works at another covered entity. Even though this person is a radiology technician, he or she is going to be considered part of the workforce at that other covered entity. So they're going to have their own obligations under HIPAA not to use or disclose PHI in a way that violates the privacy rule. So this is clearly different than a situation where we've got somebody breaking into a house or someone, you know, maybe accessing a laptop that they found on a bus, who really doesn't have any duty or obligation to look at that information. our doctor is friends with the radiology technician, so hopefully the radiology technician isn't going to look at this with malicious intent. If they're friends, probably that it's safe to say that that's not going to be a problem for us here. We can probably look at the identity of that individual and view that as a positive factor weighing against this being a breach. The mitigation factor is also pretty helpful too, because in this scenario, we've got our radiology technician, and if this individual is notifying our family medicine doctor about what happened right away, or if our family medicine doctor realizes what occurred and contacts the radiology technician and, asks them to delete the text, delete the photo, or the technician writes back and says, hey, I think you sent this to me in error, I'm deleting it from my phone. Those kinds of factors are fairly positive in this situation. So I think that in this scenario, our family medicine practitioner, made a mistake, but probably this isn't something that's going to be considered a breach.
Okay, so case study 5, the wayward vendor. In this scenario, a skilled nursing facility contracts with a vendor to do revenue cycle consulting. The vendor provides services, and they generally follow the terms of the contract, so they're not really doing anything too crazy until the vendor, without the skilled nursing facility's permission, uses patient names and addresses to market other products sold by the vendor. Because without knowing it, the vendor actually performs and provides these Medicaid estate planning services to help individuals protect their assets. So the skilled nursing facility finds out about these vendors' marketing activities when, during a meeting one day, the resident mentions to the financial director that the Medicaid estate planning services of the vendor will allow this resident to keep their assets and stay in the skilled nursing facility long term. So the resident is ecstatic. The financial director has these alarms starting to go off, thinking they have no idea that the vendor was actually performing these sorts of activities and using the PHI in that respect. So as we're starting to think about this issue, there are a few things that we would need to think about and get a little bit more information on. The first thing to consider is really the nature of the relationship between the skilled nursing facility with the vendor. So was the vendor actually acting as a business associate agreement, and what type of contract and agreement was in place? Just as a reminder, a business associate is somebody who performs services or functions or activities either for or on behalf of a covered entity when those activities involve the use or disclosure of the covered entity's patient's PHI. So they need to be kind of performing these types of activities on behalf of the skilled nursing facility, and there also needs to be access to use or disclosure of PHI. In this case, the vendor is performing revenue cycle consulting services. That typically involves things like reviewing claim submission, helping with billings, providing consulting on things that they could do to improve their billings and in their system. So it's very likely that they did have access to patient PHI and claims and billings information, which would very likely make them a business associate. Because of that, the contract would need to have certain business associate provisions in place. So we need to make sure that the BAA actually hit all of those elements and contained all of those required statements. So we'd really need to get more information on the relationship and what the contract was. The other thing we need to be thinking about is whether this type of activity was actually permitted. So aside from the business associate agreement and aside from what the vendor was permitted to do or hired to do, does the marketing to the patients fall within that, or is that in fact outside of the scope of what the original arrangement was? You can kind of break this down into 4 separate issues. So first, you should be thinking about, did the skilled nursing facility have the right arrangement? Did they actually have a business associate agreement? Did that business associate agreement hit all of the necessary elements? And were the permissions and those authorities granted to the vendor things that the skilled nursing facility actually had authority to do? If they didn't have the right sort of arrangement, did the vendor's activity actually constitute a violation of a privacy rule? So did this go outside of something that they would have been permitted to do? 3, was it a breach? If it did go outside of the privacy rule, does it arise to that sort of level? And if so, who actually is responsible for that breach? So as we mentioned, the privacy rule does require covered entities and business associates to enter into the business associate agreements. The failure to do so is a violation of the covered entity. So the skilled nursing facility would need to make sure that it actually has that agreement in place. And as I mentioned, so the skilled nursing facility can only grant the vendor authority to do the types of services and have the types of access that the skilled nursing facility has permission to do. So what I mean when I say that is the covered entity, the skilled nursing facility, can't go making up all sorts of authorizations and give that permission to the vendor if it doesn't originally have that. So we need to be thinking about making sure that the things that the vendor did actually are permitted first under the business associate agreement, but also just generally under the privacy rule. So if they didn't, if they went outside of that business associate agreement and they started acting kind of on their own regard, that's going to be a violation of the vendor. So that kind of shows you the flip of who's responsible and who's ultimately required to comply with these requirements. Again, HIPAA does require patients' authorization before they use information for marketing purposes. So this is one of those things where the skilled nursing facility would really need to make sure that permission was actually granted from the patient for the vendor to perform these services. If the vendor did market without patient permission, the activity would be considered to be a breach, and they would need to follow with the 60-day notification requirement. So ultimately, to answer this question, you really need to dig into the type of the relationship that was involved and what the actual contract and the business associate said, and then making sure that you actually had the patient authorization for that marketing activity.
Okay, so our last case study number 6, Facebook, the bane of our existence. Now, this isn't to pick on Facebook. Facebook is great for social media, for personal things, but like other kinds of social media, if used in the wrong way, Facebook can be very problematic for healthcare providers based on what their workforce does with that technology. So when we talked earlier about training, a fact pattern like this one is intended to illustrate the importance of training personnel about how they use social media, whether as part of their job or how the things they learn of in their job need to be separated or walled off from what they're doing with social media in their personal life. So what's going on here is we have a staff member at a long-term care facility who's very active on Facebook. She likes to post about what's going on with her life. She sometimes likes to complain a little bit about work conditions at the skilled nursing facility. Things aren't always so rosy over there, apparently. And one day, she happens to post a photo of a resident's soiled laundry, and she captions it by saying, "Can you believe how gross these people are?" She underlines and bolds and italicizes it and puts it in, question marks, exclamation points, really calling it out in the posting. Now, the photo itself is really a picture of laundry. Viewers, anyone looking at Facebook, they're not really going to be able to see much or anything about the resident at issue, that person's face, or anything about their name, any identifying information about that individual. That's not apparent from the post itself. However, a colleague of our staff member at this facility, another staff member who happens to be a Facebook friend of this person, sees the photo, kind of upset about it, and notifies her supervisor about what's going on with this posting. So how do we analyze this situation? Because, at first glance, this one looks pretty bad. I mean, we definitely have something posted to a very wide audience of people, similar to the example we talked about with Twitter. We don't know exactly who is seeing this information. They, certainly don't have any kind of obligations under HIPAA or any other sort of privacy law to safeguard that information or to not further disclose that information. There really isn't much you can do to mitigate that information once you put it out there. You can't really unring the bell, as people say. So we do have all this information out there that's posted. So at first glance, it looks pretty bad for the facility in terms of HIPAA. But, the thing to really be focused on here is whether the disclosure at issue is actually a disclosure of information that's going to qualify as protected health information. And actually, it's a little bit more specific than that. To have protected health information to begin with, you first need to have what's called individually identifiable health information. And as you'd imagine, it gets pretty technical in terms of how those terms are defined in the regulations. But basically, individually identifiable information, that's going to be information that's related to the physical health condition of the individual at issue, created by the provider, received by the provider. So those parts of that definition, so far, it seems like we're probably tracking on it, but it's really the last part of the definition that we want to think about here, whether it's actually identifying the individual. Does the information at issue identify the individual, or is there any reasonable basis to believe it can be used to identify the individual at issue? Now, based on the facts that we have so far, probably the answer is no. If this is just one staff member at a skilled nursing facility with lots of different residents posting this photo of laundry, it seems like it's going to be pretty challenging to have a reasonable basis to believe you can take that photo and use it to pin down the identity of an individual. However, if we're talking about something that's a little bit more specialized, so if our staff member at the facility works in a particular ward where they have a limited number of patients, for example, or works in a particular part of the facility that only treats patients who have a particular type of characteristic or condition, that starts to change the facts a little bit, because now you might be able to look at that photo and say to yourself, oh, I know so-and-so, she works in the XYZ department of the nursing facility and really only has about 5 patients. So I kind of think I might know who this is. Another way that our facts could change would be if we're talking about a facility in a small town or a facility that really is the only location for individuals in a geographic area. Anything where there is a reasonable basis to try to narrow down the identity of the individual at issue. So if we have those kinds of twists to our fact pattern, then we might not be in a situation where it's not a breach. But based on what we have so far, probably we're dealing with some conduct that clearly is not consistent with what the employment law guidelines, the employee handbook materials at the facility have to say. Certainly would not be conduct that's consistent with the HIPAA privacy rule, but we might not actually have something that is going to give rise to a breach here. Now, the challenge for the nursing facility down the road would be if they took this and they just kind of wiped their brow and they said, well, good thing it's not a breach, no harm, no foul, we're just going to kind of move on from this and not do anything else. The way that becomes an issue is if we do have a breach down the road that OCR investigates and they then learn of this particular situation, chances are that the OCR is going to look at that and say, well, nursing facility, you guys had this earlier incident and you really didn't take it all that seriously because you didn't do anything to try to train personnel about not posting these kinds of photos, not taking these kinds of photos, not sharing this kind of information on social media. And obviously, the technical sort of parsing of the HIPAA breach regulations is one thing, but the broader point of a hypothetical like this is that if you do have individuals in your workforce who are engaged in this kind of behavior, you want to take that behavior and you want to use that as a teachable moment to try to educate folks about what not to do in the future, so that if there is a problem down the road, you can point to the positive steps that you as an organization took from that situation. So with that, we are going to wrap it up for today. Both of our phone numbers and our email addresses are on this slide here. If you have any questions about any of the things we talked about today, or if you have questions about the toolkit generally, if you're interested in being added to our mailing list, please feel free to call either one of us or send us an email, and we will be sure to add you to our list. So thank you very much for joining us.